Okay, so through this webinar, we aim to contribute to a better understanding of the issue of stand trial, findings of incompetence to stand trial, the trends in competency-related forensic services for Michigan, and what these trends mean for access to all types of behavioral health services. Through the efforts of the Mental Health Diversion Council, which is a task force that was developed to examine challenges for people awaiting trial on criminal offenses, sometimes minor misdemeanors, who are sent for evaluation of their competence to stand trial and found incompetent to stand trial. The task force developed a Memorandum of Understanding, or MOU, to further help counties examine these issues locally. The MOU is an agreement between the courts, the community treatment providers, and the prosecutors. We plan to describe the purpose of the MOU and what it does and does not mean for participants. Near the end, Prosecutor Becker will present a case example to illustrate how this process can be successful. Next slide. Actually, we're on the next slide. Thank you. In order to understand the development of the MOU, it's important to understand its origins. Our work group stemmed from a committee of the Mental Health Diversion Council, which was established via executive order in 2013. The Diversion Council works to decriminalize mental illness with the priority of preventing unnecessary incarceration of those with mental illness. Next slide. The purpose of this slide is to illustrate how the Diversion Council is comprised of numerous stakeholders across Michigan. Next slide. So the Diversion Council has many goals and responsibilities. However, in this slide, we highlight a charge particularly relevant to the work group examining issues for persons found or at risk of being found incompetent to stand trial. That is, the goal of the Diversion Council is to help communities adopt and implement a diversion action plan to improve efforts to divert individuals with mental illness, intellectual and developmental disabilities, including comorbid substance abuse disorders, from criminal justice involvement. Next slide. So like the Diversion Council, the Incompetent to Stand Trial, or IST, subcommittee is comprised of various stakeholders across discipline and region. Chris Becker, Trader Mack, Stephen Mays, and Dr. Pinels serve on the larger Diversion Council as well as the IST work group, which was developed specifically to address IST issues in jails and prisons. The work group includes representation from the courts, community mental health, protection and advocacy, and various groups within MDHHS, including the Forensic Center, legal, and the medical director of behavioral health and forensic, Dr. Pinels. Next slide. Okay, so this past July, the proposed MOU was sent out to every county in the state regarding the possibility of diverting misdemeanor cases from the Center for Forensic Psychiatry and or from prosecution. First, it's important to state that the MOU is not an attempt to dictate what happens to cases in your county. It's a voluntary agreement between stakeholders that allows for individualized discretion for any particular case involving a defendant charged with a misdemeanor. Also, it's important to note that this is not simply an attempt to divert work from the Forensic Center or other state of Michigan hospitals. Rather, it is about working toward the goal of decriminalizing the mentally ill by diverting individuals with mental illness from the criminal justice system, specifically individuals charged with low-level offenses. Referrals for competency evaluation remain an option for misdemeanors in this MOU. So the MOU was developed after lengthy and in-depth discussions by representatives of all the major partners who are dealing with the interface of mental illness and the criminal justice system. In this webinar, we'll review the trends in referrals to the Forensic Center and findings of incompetence, which are ever increasing. The MOU is our best attempt to deal with this issue quickly and effectively. The importance of these efforts stems not only from the backlog in competency restoration treatment at state hospitals, but also from the goals of the Diversion Council, that is, minimizing unnecessary incarceration of individuals with mental illness. So the MOU does not require legislative changes. It's in keeping with the current mental health code as well as legal standards. It was developed to balance the needs of individuals with mental illness and public safety. Essentially, the MOU is an attempt to decrease the time individuals spend waiting for competency restoration evaluations and treatment, either at the Forensic Center or at other state hospitals, especially for those who can be better served in the community, as well as to highlight better options for individuals with serious mental illness, especially misdemeanors. Next slide. Okay, so the MOU is an agreement between the prosecutor's office, the CMHSP, and the chief judge for each respective county. The MOU is an effort to bring stakeholders together to divert misdemeanors and to prioritize treatment as an alternative to incarceration and or prosecution. So we will review data to show that the number of cases that we're talking about here is relatively low. Last year, only about 60 defendants statewide charged with misdemeanors were opined as incompetent to stand trial and likely to attain competence with treatment. Most counties had only a few misdemeanors, at most considered IST. So we hope this MOU will remind us of the option of diverting misdemeanors out of the competency evaluation process and or from the competency treatment process. For example, rather than referring a misdemeanor for a competency evaluation at the outset of a case, the prosecutor or defense attorney may refer the individual to their CMHSP for assessment of treatment needs. Of course, it's not always obvious which defendants may or may not have a mental illness or intellectual disability or require treatment. And as such, diversion may be introduced after the competency evaluation. For misdemeanors found IST, the defendant could be diverted from competency restoration treatment. Instead, the prosecutor may file a petition with the probate court and refer to CMHSP for review and treatment. Next slide. So this slide reminds us that the American Bar Association acknowledges the importance of multiple professional organizations working cooperatively to improve the administration of justice in criminal cases involving mental health or intellectual disability issues. Next slide. The Mental Health Code currently has in place the provision of diversion services by CMHSPs to divert persons with serious mental illness or developmental disabilities from possible jail incarceration when appropriate. Next slide. So let's talk now about the issue of incompetence. The issue of incompetence can be raised by defense, prosecution, or the court, and then the Forensic Center conducts the court-ordered competency evaluations and offers an opinion to the court on the issue of incompetence. Next slide. As a review, incompetence, of course, is not about whether an individual can benefit clinically from mental health treatment. Rather, it's defined by statute as pertaining specifically to a criminal defendant's functional capacity to stand trial. To be incompetent to stand trial, or IST, it's not enough to have a mental illness or suffer from a mental condition. That mental condition must impede the defendant's ability to understand their legal situation and or assist rationally in their defense. Each case may require different resources or capabilities from the defendant. As such, the court makes the final or ultimate determination as to what would be required and whether the defendant is competent or not. Competency restoration treatment, then, is not intended to serve as a general access to clinically necessary treatment. Rather, it's about providing treatment specifically to prepare an individual to competently face criminal prosecution. Next slide. Okay, so upon a finding of incompetence, the court may order a defendant to undergo treatment specifically to render them competent if the court determines that there is a substantial probability that, if provided a course of treatment, the defendant would attain competence to stand trial within the time limit established by Section 1034, which, as you may know, is 15 months or 1/3 the maximum potential penalty if convicted, whichever is lesser. Next slide. Okay, so while of the 5 state hospitals, the Forensic Center is the only one designated in the Mental Health Code to conduct competency to stand trial evaluations, any of the other state hospitals may provide inpatient treatment for competency restoration when the Department of Mental Health is appointed the medical supervisor of treatment. Just a few years ago, the CFP was only a 210-bed hospital. However, with the opening of an 8th unit and expansion of beds available, we are currently at 272 beds available. The proportion of forensic patients at the regional hospitals has significantly increased over the years. So you can see this is a matter of supply and demand. Next slide, please. Okay, so the CFP is required to complete the competency evaluation within 60 days of the court order, and the majority of our competency opinions are completed within compliance and within that time frame. Even so, referrals for competency evaluations inherently introduce delays in the legal proceedings, even for individuals who are ultimately opined and adjudicated competent. This is because of the time involved in scheduling, conducting, and completing evaluations, which require coordination with the sheriff for transportation and other scheduling issues such as multiple appointments due to no-shows or repeated assessment, the need to request and wait to obtain necessary collateral information, and so on. For those cases in which the CFP offers an opinion of incompetence, we also offer an opinion regarding the likelihood of the defendant attaining competence if provided a course of treatment within the time frame permitted by statute. Next slide. Okay, so when considering the issue of restorability or likelihood of attaining competence, we consider the nature of the mental condition. In other words, is it something that is amenable to treatment? And if so, is the treatment likely to be effective within the time period allowed by statute? Obviously, for some misdemeanors, this would translate to only about 30 days for treatment. As such, some individuals would not be likely to attain competence within 30 days, and as such would be opined and or adjudicated not likely to attain competence. When this is the case, the individual is typically petitioned by the prosecutor for treatment through the probate process and not through the criminal court system. Next slide. From 2010 through 2018, there was about a 50% increase in referrals from the court for evaluations of competency to stand trial overall. Last year, we received about 4,800 court orders for forensic psychological evaluations, and over half of those were for evaluations of competency to stand trial. Most orders are for defendants with felony charges. Last year, only about 15% of all competency evaluations completed were for misdemeanors, which was just about 350. However, this is still a significant increase from 2010, when we saw only about 200 misdemeanors. Furthermore, while 2017 and 2018 were relatively comparable in terms of incoming court orders, the current year is on pace for a record high in terms of number of referrals for forensic evaluations. As of the end of last month, we had received about 7% more orders overall as compared to the same time last year. If this trend continues through the end of the calendar year, which is only about a month and a half, this will translate to about an extra 300 additional evaluations this year alone. Next slide. So the question is, why are there so many referrals? What's the reason for the ever-increasing number of referrals for forensic evaluations? It's likely the reason for the continuous increase in referrals is multifactorial. However, Some courts have indicated that they are seeing more misdemeanant defendants who are mentally ill and not getting treatment locally, so they end up referring the individuals to the forensic center for competency evaluations with the thought or hope that they could at least get some treatment. Regardless of the cause, the increase in referrals certainly impacts the entire system. Next slide. Okay, so not surprisingly, the increased number of competency evaluation has corresponded with an increased number in findings of incompetence. In 2010, there were less than 300 opinions of IST. Last year, there were over 500. Note that only about 140 were for misdemeanant offenses. Okay, so of those misdemeanants opined IST, only 60 were opined as likely to attain competence with treatment. The other 82 were opined not restorable. So it's those 82 that would likely be petitioned via the probate process for treatment after all. Okay, next slide. Okay, so this slide illustrates the higher rate of opinion of incompetence for misdemeanants as compared to those charged with felony offenses. Misdemeanants represent a disproportionate number of IST opinions. Recall that only about 15% of all competency evaluations last year were for misdemeanants, yet those 15% represented 27% of all of the IST opinions. In other words, a defendant charged with a misdemeanor and referred for competency is much more likely to be found IST than a defendant charged with a felony. Last year, the IST rate for misdemeanors was 40%, which is significantly higher than years past and significantly higher than for defendants charged with felonies. The Forensic Center's IST opinion rate has not increased significantly for felony offenses over the last several years. Last year, the IST rate for felonies was 19%, which is relatively comparable to years prior, as you can see. In contrast, we have seen an increase for misdemeanants. This does suggest an increase in the rate of misdemeanants presenting with mental illness. Next, not yet. Recall also that a ruling on incompetence is based on what tasks the court determines necessary to proceed. Defending against a misdemeanor may not be as taxing as defending against a felony. As such, the higher rate of incompetence for misdemeanants may reflect a higher rate of acuity among the defendants charged with misdemeanors. Lost my page.
I think I went forward when you said no, not yet. So I might
okay, my screensaver went on. All right, we're good. Defendants charged with misdemeanors and opined IST are much more likely to be opined as not restorable or not likely to attain competence within the time period permitted by statute. This is not necessarily surprising, since for some defendants this would mean only up to 30 days permitted for treatment. Last year, over half of all misdemeanants opined IST were also opined as not likely to attain competence. This is a marked increase from 2010, at which time only 13% were opined as not restorable. The increased rate of not likely to be restored over the years also suggests the possibility that there have been increasingly more serious mental health issues underlying the increased referrals for competency evaluation. As such, the lower time frame for restoration, along with the issue of psychiatric acuity, likely contributes to the higher rate of not likely restorable opinions for these misdemeanants. So, to break it down, last year, CFP offered 356 competency opinions on misdemeanants. Of those, 142 were opined IST. Of those, the majority were opined IST and not likely to attain competence. In other words, likely to have the charges dismissed. Only 60 statewide were opined as incompetent to stand trial and likely to attain competence with treatment. Those 60 opinions are the best estimate of the number most relevant for this MOU. For those 82 found not restorable, the system already has in place the diversion to treatment outside the criminal court system. Specifically, the 82 would likely be adjudicated IST and pursuant to Section 1031 of the Mental Health Code, the court would likely direct the prosecutor to file a petition with the probate court asserting that the defendant is a person requiring treatment as defined by Section 401 or meets criteria for judicial admission as defined by Section 515. Next slide, please. Okay, so what does this mean for your county? This slide shows the portion of total competency evaluations by county. Last year's distribution by county of order is comparable to the last several years. That is, Wayne County represents nearly a quarter of all competency orders, followed by Oakland and Macomb at around 9%, and then by Genesee, Washtenaw, and Kent at around 5%. This is not surprising in many ways since these counties have very busy criminal courts generally. Okay, next slide. All right, so this figure shows the top 15 counties for total IST opinions broken down by severity of charge. So the blue is the misdemeanors and the red are the felonies. The top 3 counties for misdemeanor ISTs corresponds to the highest referrals for evaluations. Most counties have more felony ISTs than misdemeanors. Only 8 counties had more than 5 misdemeanor IST opinions last year. So again, this is what we're talking about here for when we think about the MOU. Only 8 counties had more than 5 misdemeanor IST opinions last year. Next slide.
Dr. Ines?
Yes?
What I'm realizing is, I'm sorry, Monique at the association. What I'm realizing is that we have a lot of participants who are using phone-in only, and they're not logged into the webinar. Therefore, they don't have the ability to use the chat function for questions. So if you have a spot in the presentation where you feel comfortable with me unmuting the lines, I would like to give those who are just doing audio only the opportunity to pose any questions they may have.
Let's wait till the very end, though.
Absolutely.
This is Bob Sheehan. Only given the large number of phone call folks we have, that could really take over the whole webinar. So let's wait till the end if we could.
Right, and we're near a place that would be a good place to pause when we turn it over to Chris. We're almost done with these numbers here, so we'll take a break for questions shortly.
Perfect.
So now we're on the treatment of persons found IST. So reference to this administrative rule is included here to emphasize that IST treatment is specifically directed toward the focused forensic issue of rendering a defendant competent to stand trial. In other words, preparing them to face criminal prosecution. Next slide. All right, so to review, over the last several years, there's been an increase in number of evaluation orders, an increase in rate of IST opinions, particularly for misdemeanors, and an increase in rate of not likely to attain competence opinions, especially for misdemeanors, all of which contributes to an increase in number of IST opinions. There's also been an increased delay in community placements from hospitals. For all of these reasons, there have been delays in hospital admissions for competency treatment and other non-forensic patients because of the larger proportion of forensic patients in the state hospital system. At present, we have about 120 individuals awaiting admission to a state hospital for IST treatment, and less than 10 are misdemeanors. Most recently, the average wait time was about 110 days. Clearly, there must be a better way to provide community-based care for people with behavioral health needs. Next slide. All right, brings us back to the MOU. Although the MOU focuses on diversion of misdemeanors, which represent a small percentage of the IST admission wait list, the diversion of misdemeanors would still open critically needed hospital beds for those charged with more serious offenses, and, if done in partnership at the community level, could still ensure proper treatment of mental illness and assessment from a public safety perspective as to whether diversion makes sense in a particular case. By ensuring that only the most criminally, legally sound cases proceed to trial and the least serious offenses are diverted, Prosecutors and other stakeholders can ensure that people with behavioral health needs are not pulled into the criminal justice system inappropriately or unnecessarily. And this is the part where we're going to pause and turn it over to Chris for an example. We could also take questions.
Well, if you want, there is one question I just saw pop up regarding who will notify the stakeholders. The prosecutors will not sign unless the community mental health provider is on board, and community mental health has never heard of it. So I don't know if you want to, Bob, if you want to handle that?
Yeah, I think after this webinar, we'll send the notice out again. It went out about, Don and Chris, when did we send out that MOU? About a month and a half ago, maybe two?
It was, I think longer than that. It was July, August, somewhere in there.
Yeah, it went to the CEOs, and then some CMHs, their court liaison or their person working with the court most directly or the prosecutor may not even have seen it. So we'll send it out again, along with these slides, I think, to help everybody with their memory and move it forward.
I don't know if there's any other questions right now. If we want to open it up at this point in time.
I am unmuting all of the lines right now. Please don't rush the line, as they would say in person. So for those of you participating by audio only, please know that I am unmuting lines right now. So if you have a question, try to get it in now. And I am still unmuting. We do have a lot of lines that are audio only. I apologize. So still unmuting. Still unmuting.
Are we ready for a question?
Yeah, so I still have about 15 more to unmute, but I have unmuted most of the lines. So again, if anyone has any questions for Dr. Reines or Chris Becker, please feel free to chime in now.
This is Christine Gebhardt. I don't know that this is a question as much as a comment. I met with all of my judges and prosecutors when this MOU first came out up in North Country Community Mental Health area. And, from what I've heard today, the issue for us seems to be that while our numbers are small, it's really up to the prosecutor whether or not they're going to do a diversion. And unless they divert the person, we don't have the funding to serve those people in jail. So their first response to me was, are you going to get more money to serve people? To which I had to say no. And they don't feel real strongly about doing diversion. So it seems to me like the heavier lift needs to come from the Prosecutors Association rather than ours.
I can jump in on that. I guess I'm somewhat understand. I mean, I agree with you in terms of, I think the prosecutor to some extent is the gatekeeper. It is for, it's almost like many of the specialty courts that we have now. So it is, we are a gatekeeper in terms of we have to be on board to divert them. I guess I don't understand your specific issue in terms of the funding to divert them to get the treatment you don't have the funds for, and
if they're in jail, while they're still in jail, I don't have GF funds to treat them. I can only treat them if they're diverted, but that relies on the prosecutor.
Sure. And I agree, because that's the whole idea is, because our Kent County Jail is, like I think statistics show like 40% of the people going in there have some sort of mental illness, and part of this it would be to try and get them out of the jail, because I think most people agree that jails are not properly equipped or necessarily the best places for people with mental illness. But the key is from the prosecutors, and I think everybody would agree, is we want to get them out into the community, but get the proper treatment out there. We don't want to put up, just release them, and that was the thing. The other option is just, kick them loose. We don't want to do this, so we're trying to do a handoff to the local community mental health provider to get them the treatment. So we're satisfied as a prosecutor that, hey, they're getting the treatment, and hopefully this won't happen again if they're connected with the right resources.
Right, and yet my prosecutor says it's the defense attorneys that are requesting the competency evaluations, so they feel their hands are tied.
Sure, they can request it, but that's one of the things the MOU and I've had conversations we get into to talk about this is that they request it, and they very often request it, but if I haven't had any complaints, or when we say, hey, we're going to divert this, we're going to turn them over to somebody else, they're not going to scream and yell saying, no, don't do this. We really want them to go to the forensic center and be caught up in the system for the next, 90 days, 60 days, whatever it is. Their defense attorney is usually pretty amenable if you say, hey, we want to hook them up with this program and get them out of jail and get them into treatment.
This is Bob Sheehan. Let me add to that, if I could. That's what the MOU does, Christine. Really provides a floor for the agreement. It doesn't bind anybody. It doesn't bind the prosecutor to agree to a diversion, nor for you to take. And what it says is, if you could agree on that, that'd be far better than keeping them in jail. And you're right, Christine. It doesn't bind you to do jail-based services. It really says, let's see if we can work out a way to treat somebody in the community as opposed to keeping them.
This is Monique. I apologize. I just got completely disconnected, so I'm trying to come back in. Give me just a moment.
Well, that's okay. I see we have another question regarding how is CMH qualified to render a forensic evaluation while the statute directs that duty to the CFP? And maybe I'll jump in on this one, and anybody else can do. We agree, and the idea is not to have the CMH do a forensic evaluation. And I don't know if we talk about it now, but part of it is the prosecutor, whoever it is, maybe based on that person's history that they see before, being okay with not sending them for a full forensic competency evaluation right off the bat. So we're not asking the CMH qualified to render a forensic opinion. It's kind of an agreement saying, with this specific person, this specific case, we're okay with doing that and hooking them up with mental health services and not putting them through the forensic center if that's possible. But once again, that's an agreement, and that's a voluntary determination by the prosecutor, the CMH, and whoever the other parties are.
Then I want to put them in jail.
Exactly.
There
Sometimes.
are a couple more questions.
Everybody has to go to jail. Maybe we would all be better off if they were in the mental.
Donna, go ahead, Donna, if you would respond. Or is that
Right. As Chris mentioned, sometimes a defendant in a community is well known to suffer from mental illness and may have, an acute relapse. In order to get treatment, then if the main issue or main concern is a provision of treatment for that individual, I think the MOU just highlights that they don't have to go through the competency process to gain access to community. They can go through the probate court system. And I think, as we mentioned earlier, some cases are new cases. They're not well known to the community, or they're not quite sure. And, in those cases, of course, the referral for the evaluation would come to the forensic center, and we would be happy to offer an opinion on that. Then, at that point, the prosecutor can determine whether or not they want to pursue the criminal charges.
Double the number of beds at the forensic.
And maybe this would be a good time. I don't have a slide, so maybe I'll talk about my piece and maybe give some illustrations of we think how it's supposed to work, and then we can follow up with some other questions. What we've done, we were, I think, the first county to have and this was all our district courts. Obviously, these are misdemeanors, so I have a number of district courts, so I had to approach all our district court chief judges to get them to sign off. They were very supportive on that. And the biggest thing for me, kind of reemphasizing what the doctor says, is, we were having issues in Kent County getting our serious felonies, not getting them into treatment. I had to dismiss 5 cases because we lost jurisdiction because they were not made competent within the 15-month time frame they had for the felonies. So anything we can do to get those, relieve the pressure on the forensic center, to get those more serious cases treated, I was supportive. And looking at the numbers, when you look at it, Kent County, one of the larger counties, we only had about 9 incompetent stand trial misdemeanors. So I'm willing to trade those off at the bottom end to hopefully get those cases that I really want determined one way or the other in a timely manner to be done. So right after we signed the MOU, we had a domestic violence case. And domestic violence cases are, a violent case. It's very serious, but it requires communication between all the parties, and I think we have that in Kent County in terms of, I talk with my staff, giving them a heads up about, hey, we have this new program. If there's a misdemeanor case that may be they want a competency on, I want to see them. So one of my APA 1s, lower level, says, hey, we have a defense attorney who's going to request a competency on this domestic violence. I took a look at it. Right off the bat, I saw she had, it was a female victim actually. Even from the report, you could tell there was mental health issues. She was just kind of acting crazy. Her mom, who was the victim, said she was bipolar schizophrenia. She had broke a window, shoved her mom, fairly garden variety, if you will. No serious injuries. While she was incarcerated, I made contact with Network 180 as our local provider. They have a person embedded with the jail that I've talked with because we've had all these other issues. So I reached out to her, and she had basically a history of what this lady, the treatment, the involvement of Network 180. When she gets off her meds, this happens. She's got a case manager through Cherry Health. We reached out to them. They were willing to make contact with her to get her the appropriate meds, to get her back on the meds because she was off of them. And Mom was okay with it, and we ended up just dismissing the case. Never went to forensic, the forensic center never saw it, and, this is just a matter of communication, so it's nothing earth-shattering, but we had a background looking at her prior admissions to the jails, her mental health history, and we diverted that one. So that's kind of what we were talking about, a success story that we got her hooked up with treatment. Conversely, I've had other cases since then where, going back to this, kind of emphasize, this is an agreement, and we are the gatekeepers, where I've had 2 other cases where the individual has, there's nothing in the report that would indicate the defendant has a mental health history, and MDOP, and I think the other one was another domestic. So I was not as comfortable, and there's nothing in the jail. They weren't in, getting mental health services in the jail or anything like that. So I did not divert those. I said, okay, there's nothing we can do. The defense attorney's saying, yeah, they're acting strangely. They're not responding to me. I need a forensic. They are going through a forensic. We're going to send them on to the forensic center to get the treatment. But that's what we're talking about, is trying to at least look at these misdemeanor cases early and have a screening process. And, I think in the system, it becomes automatic. Defense attorneys request them. We, as prosecutors, don't put up a fight, and we're just sending these cases on to the forensic center, when maybe if we take a look at them early and look at the background, we can divert some of those to save space and time for the forensic center to deal with the more serious cases. So it's, nothing earth-shattering, nothing, too tremendous, and the benefit, I think, is, what we can gain in really providing services, if we can, like the individual we dealt with, to get her into her Cherry Health, get her on her meds, and not keep her locked up or in the system, if you will, for another 60 to 90 days going through the whole forensic process. I think that was most definitely a better outcome for that individual for sure, and if we can do that in the future, that would be a lot better. So that's essentially what I had. So I don't know if we want to deal with more questions at this point in time.
Chair Fuller with a question.
Sure.
Hi, guys. So what I've seen, or what we think we see, actually we thought we had more cases than are represented here, so I appreciate the numbers. But when we see people that do come in with a mental health issue, we've been fortunate to have the local mental health make sure they get back on their meds while they're in our jail. And they may be set aside to go for an IST, and then in the meantime, the meds really take care of the problem. And so I'm looking for the hope that there's some sort of mechanism where instead of dropping the case, the person can be held accountable because of their actions, and they were off medication, and I guess a review process short of the full IST is what I'm talking about.
And I think that's possible, at least from my perspective. I mean, I suppose that's, once again, you have to sit down with, I think the MOU is flexible enough that if you want to sit down with your prosecutor and your judges, I mean, judges do have the ability to take cases under advisement. So, plea under advisement, especially for misdemeanor cases, we see it at least commonly here in Kent, where you kind of put on probation, they report to court services, and as long as they do everything okay, the case is ultimately dropped after 6 months to a year. That is a potential, but that's something, once again, you'd have to talk with your local system participants to see if that's something like that. You could do something like that, I think.
Thanks. I'm real open to visiting with our judges, and we've got some that are really listening to these things, so that's a help. The MOU idea helps, and I appreciate the advice there.
So, Chris, we have a lot of questions popping up on the chat function.
Yep.
I address some of those?
Yeah. If you want to take the one about we are struggling to implement the changes in AOT with the probate court in the collaborative manner. Communities, we need to have a solid AOT process in place, correct? Bob, we're not participating in anything like that. I don't know, maybe somebody else can answer that.
I think I could jump in on it, Chris. This is Bob Sheehan. I think it's from Kathy Junker. Kathy, that's a great point. It's really a separate issue, though, as you know, really related to this IST thing. We're working with Judge Mack and with Dr. Pinos to develop a training for folks across the state, because in some parts of the state, AOT, for everyone's benefit, assisted outpatient treatment, what you might call Kevin's Law. In almost every county, alternative treatment orders were converted to AOTs. But AOTs have far more record-keeping and planning involved, and I don't think a lot of judges knew that. I also think it was used by some judges really appropriately, but some pretty broadly. And so all of a sudden a wave of people that wouldn't normally be on the CMH caseload are all of a sudden there. So we're going to be working with Judge Mack. He and I just got off the phone off the email a couple days ago to get funding for this. We all know that in New York and Massachusetts and states where AOT was really successful, there was additional non-Medicaid funding for folks, because a lot of these folks are non-Medicaid. So let's keep working on it, Kathy. Don't let that get in the way, though, if you don't mind, for this IST initiative. The IST folks are small in number, and with the sort of hand-holding between the prosecutor, defense, judge, forensic center, and the CMHs, we think we can handle these in a way that for which supports don't exist in the AOT.
And with Chelsea joining.
So I hope that's helpful to Kathy. I'll pass it back to you, Chris, for other questions.
Because I think Stein.
Can we next address the comment that says also, can you talk about if someone refuses to participate in diversion mental health treatment unless the person is on an alternative treatment order and being served by a case manager or PO who would monitor the individual's compliance with diversion treatment?
I missed that one. So if somebody refuses to, so they refuse the mental health treatment, then what do we do? Is that essentially what it is?
It says if someone refuses to participate in diversion mental health treatment unless the person is on an alternative treatment order and being served by a case manager or PO who would monitor the individual's compliance with diversion treatment.
Well, I mean, I guess that falls back in if they refuse to comply. The one case we had, they were working with a case manager, so I guess I'm trying to wrap my head around how we would send somebody off that be involved with community mental health in some fashion, that they wouldn't say, hey, the one we did, they had everything in place, they were made contact, they were moving down that road, so I guess if you say in like 2 weeks they drop off their meds again, I suppose that's we did not go down that road that far to see if it was going. We waited till she was, getting her treatment and seemed to be on the right path at that point in time. Statute of limitations, we always refile charges later if it became that son of a concern. So just because we dismiss it at this stage doesn't mean we can't refile them and say, hey, we tried, and go down that road again. I guess part of it is just trusting your provider communication once again to say, hey, we're having issues with this person if it becomes that bad.
This is Bob Sheehan. Let me jump in. Chris is exactly right. So the CMHs who, if they ask that question, know that the CMH isn't taking over the court's role or anyone's role in terms of ensuring compliance, because there's no order. This is an IST issue. So if the person doesn't comply, the CMH should use all the techniques it normally does to help somebody comply, but if they still won't, to get a hold of the judge and the prosecutor. And because, as Chris said, the person can be retried if they don't cooperate with the IST.
Because you can be retried at any time if you gain income.
So this is Monique again, just so everybody's on the same page. We also had a request to get IST numbers by all counties. Not sure if that's something somebody wants to do. We also have another 4 more questions that have popped up. If you can you see those, Chris?
I see. Well, I guess the next one I see is, I appreciate this information and the need for diversion. Yeah. However, the greatest impact being confined to 8 counties. Why aren't efforts being focused there? I think we're aware of that, and we've done. We've reached out to the bigger counties, and definitely are trying to engage them much more, because the problem is there. But we also didn't want to create a two-tiered system where maybe the bigger counties are aware of this, but other counties, even though it doesn't happen often. It does happen, and we want to try to get everybody on board so we have a consistent, system for everybody in the state. Person in, the Upper Peninsula isn't getting treated different or doesn't have the same, they will, but doesn't have the same ability to do this as somebody in Kent or Muskegon. So, we're well aware of it, and we are trying to focus there.
Okay. Do you want to address the next one?
Are we including AOT orders for people while still in jail? This will reduce the cycling in and out of the criminal justice system over and over. If all we do is stabilize while in jail, many stop taking meds once released and offend again. I think that goes back to the question. While they're still in jail, but then we talked about warm handoffs, to your local provider to give them the person to make sure they're continuing their treatment and medication while out of jail. And that's the biggest thing we always hear is when, we just keep people loose, you let them out just like you do anybody else on the street corner from the jail, they're much more likely to not follow up. If you have that warm handoff, and this is kind of what this is trying to have a warm handoff, there's communication between us, the jail, and the local provider to keep that person engaged and in treatment to keep them on their meds so they won't reoffend. Can I guarantee they're never going to reoffend? No, but I think we have a much better opportunity to prevent that with this sort of warm handoff.
Okay. And then do you see the question about delayed sentence under MCL 771.1?
Alexis are on the...
I do not. I don't see that.
Okay, so there was a question that says, judges do not do plea under advisement. You may have a delayed sentence under MCL 771.1.
That may be the law, but I'm telling you, there's people take pleas under advisement. I've at least in Kent, I've seen it done. We do delay of sentence as well, but there's pleas under advisement, and then that especially district court, that happens. And maybe it's just a Kent County thing, but I don't think so.
Okay. So response to the last question regarding stabilized while in jail, many stop taking meds once again. The comment was, I understand, but court-ordered outpatient treatment works better than just the warm handoff.
This is Bob Sheehan. I can respond to that. That's Kevin Fisher's question. That's a good one, Kevin. I think we need both. Most of the research shows that court-ordered outpatient treatment works well. Sometimes, though, you don't have to go that far. And since court-ordered treatment is sort of the last straw, besides inpatient, we try to use, whenever we can, a warm handoff. A lot of clients, especially the IST folks, are willing to do that. That's what their defense attorney's working with them to realize that, people forget that incompetency in trial means a person really can't participate in their own defense. And so it means there's a crime been committed, even if it's a misdemeanor. So we try that first, but Kevin's right. If that fails, sometimes we end up back in court-ordered treatment, whether it's assisted outpatient or otherwise. So we try to use both tools, but the least intense, least invasive first.
Okay. Chris, this is Monique again. Do you see the question regarding consent to release information?
I do not.
Okay, so some people are using the to all attendees function, and I don't know if it's going out to the whole, general population, or they're not using the to moderator function, so they're coming in general, and I'm trying to capture them as they come.
Okay.
Where does consent to release information come in when it comes to someone who is diverted from charges but doesn't follow through with treatment and won't sign consent?
I'd let you tail off there at the end.
Where does consent to release information come in when it comes to someone who is diverted from charges but doesn't follow through with treatment and won't sign consents?
Well, in terms of... You go ahead, Bob. You're going to jump in?
If they won't sign consent, then it's not going to be a treatment issue. Literally, they can be charged again, or they can be put in jail. That's what people forget. The resistance by the defendant is foolish for the defendant. So that's why the defense attorney will try to work with them to comply with treatment.
That's what my gut reaction was. Once again, this is new, so we haven't had that pop up. But if they say, I'm out, forget about it, I'm not doing it, we always have the ability to refile charges and communication with your mental health provider in terms of, hey, they've dropped off the face of the earth, we don't see them anymore. That could trigger it. That could trigger you wanting to do that. But once again, public safety wise, these are low level offenses. It's not like we're letting a murderer or somebody else out. It just comes down to communication. This isn't envisioned that the CMHs are acting as a probation agent either. That they're monitoring this person, for the next year or two to make sure they're doing. We don't envision that. We're just trying to get the person stabilized, back out in the community, and make sure they're engaged with those mental health services. In 6 months they drop off. Sure, a prosecutor could say, hey, they dropped off. We're seeing another issue again with them. We're going to revisit it and charge this case from 6 months ago. That's always a possibility. The case we diverted, the domestic violence, we haven't seen her again. It's been about 3 months. I mean, there has been any issues that way. But obviously this population, that's always a possibility. Even if we charge them, we send them through the incompetent to stand trial, and we go through the quote unquote normal way, they could still get out and reoffend in a year, and we're back in the same boat.
Yeah, I think it's important, this is Donna again, to remember the original purpose for the Diversion Council and this MOU wasn't to avoid prosecution for cases that needed to be prosecuted, but it was to highlight the fact that criminal arrest doesn't need to be the only way to find treatment for individuals. If you talk about an outpatient treatment order versus arresting them and having them receive competency treatment, two different types of treatment for two different purposes. So, it sounds like these are the challenging cases for each community, individuals who aren't compliant with their meds and who need them, but it would depend on the case on whether or not that needs to go through the criminal court system.
This is Bob Sheen. Let me add to that. I think often CMHs or some of these questions reflect that, are feeling that they are taking over the role of the court and the prosecutor and the defense attorney. They are not. We got to be clear about CMH is going to provide treatment to this person who, without that kind of treatment, would probably be in jail, and that's what we're trying to avoid. And so that's community-based care. If the person doesn't comply, we try to work hard on that. But if they don't, simply a call. I don't want to make it sound simple, but it is straightforward. A call to the prosecutor and the judge to say, or defense attorney, this isn't working out. Like you would actually with anybody who isn't complying with treatment. So I would recommend folks I think the CMHs are appropriately fearful. They're taking on a judicial or a prosecutorial role, but they're not. They're really taking on just a treatment role that they've always had to keep folks out of jail. And if the person's not complying, given all the best attempts by the CMH, they should just communicate, which is what the MOU calls for.
And this is Monique again. I have one final statement. It's not really a question, but it was a statement that was addressed to the presenters. This person says, I think a crucial component is to identify the process of who is responsible to receive information about folks determined to be IST and how they will be monitored. CMHs do not have the ability to monitor without an order and case management. So I think that goes to what you were just saying, Bob.
Right. The monitoring is simply just as you would monitor any client, knowing they have this court involvement. So you just communicate with that court involvement. But it's also, I want to reinforce, it doesn't mean that the CMH keeps them open as a case because they're under this IST order. It's a treatment issue. If they're no longer needing treatment, just let the court know that.
Right, at this point, we're not talking about turning over someone with an IST treatment order to CMHs. We're talking about diverting them from the competency process altogether. So they would be seeing them under a treatment order rather than a criminal court-related IST restoration order.
That's all I had for questions, guys. Other than the link, did you see the request for the link to be sent through SCAO and PAAM?
The link for the taped webinar, the taped of all this?
Correct, for the recorded webinar.
This is Bob Sheen. What we're going to do, too, is send the slides from today, the taped webinar, the MOU again, all to and the list we'll get from Donna of the IST numbers for all the counties. Donna has a table of that. We'll send all that out.
Well, we can't send the recording out. That will only be on the webinar. But
Right. It'll be a link, right?
All right, well, thank you.